Copyrights, I think, are interesting. They're fascinating to me. This is the legal definition you can see up here. Works of authorship fixed in a tangible medium of expression. Okay. If I decide to put draw something up here, is the act of drawing it on the wall creates a copyright in me. I own that copyright to whatever design I apply to this wall, whether or not I own the wall or not. Okay. It's created at the moment the work is fixed. And here's a list of examples you can see here, but this is pretty broad. Okay, it could be songs, it could be music, it's the content of your web page, it's what people see when they log onto your website, it's code, it's user interface if you have an app, anything that is an expression of some creative effort. Okay, some parts of the underlying code are subject to copyright protection and are available. Sort of the remedies and rights that go along with that are available in software. That's a more important, or I say a growing area of importance for software in the than patents, for a number of reasons we'll get into a bit. We'll explore the implications of what this slide says a lot in our next IP seminar. But I want to just raise it. The individual authors own the copyright. In my example, I put a drawing up here. I'm the owner of that copyright. If I never come back here again, I still own the copyright. Okay. Works created by employees within the scope of their employment are owned by the employer. Independent contractors, on the other hand, own their copyrights, unless there is a very specific writing to the contrary. Okay. You can't hire an independent contractor and issue a 1099 and own their copyrights unless it's in writing. So transfer of rights must be in writing. So this is an area where we get lots of questions on. This is a big focus on due diligence investigations that I do. Do we have the right assignment documentation in place to make sure the company owns the IP? For certain businesses, it's not as important, but if you're a software company, this is critical, really. It's really important to have that squared away. Some of the rights that reproduction, you can reproduce it, copy it, really, distribute it, performance or display, create derivative copies of the work, conduct digital performance, create derivatives. In the software context, you can kind of see where this will go. I develop an app, I develop the back end and the front end and the mobile side. I did it all in-house, but let's say I hire a third-party software development company to help me with it. Well, technically, they're making derivatives of my own copyrighted work. And your agreements need to account for that possibility. So, something to think about, derivations of copyright work. In law school, we get the examples of if I have the owner of the Mickey Mouse copyright, Disney. Right? That character is subject to copyright, but a derivative work, of course, is the cartoon, a movie, games. You can see where this can expand. This idea of derivative works. It is really the underpinning of our media industry, okay, and how these stories come from books to theater is a lot based on derivative rights and original copyrights. Yep.
So, is there a separate copyright for each instance of Mickey, or is it just,
Yes,
yeah.
It is. So you have a derivative right for Mickey in the movie, but that movie itself also has its own separate copyright protection.
Right.
So think about that a bit. It takes more than one person to make Mickey in the movie. So the creative people involved in that are really co-owners in that. Now, if you think about that, then the agreements of everybody that's involved in making Mickey the movie is really, really important. Let's see, infringement. So this occurs when one is violated one of those exclusive rights. So if somebody reproduces or distributes a right. If somebody makes a derivative of your copyright, that's a copyright violation, and you have basis to file suit. One thing I'll just mention, I didn't put it up here or in the slides. Copyright, your rights arise at creation. There is a step you need to take if you want to enforce those copyrights in court. You have to file it with the Copyright Office. It's pretty, straightforward. It costs, I think, $40 to do. But that is one affirmative step you need to take to file suit for copyright infringement. It's not necessary, but it's just you'll need to do it. Injunction, impoundment. Can you imagine that? Your product's being impounded because of copyright infringement? That's a terrible headache to deal with. Actual damages, statutory damages, I think is $150,000 per instance. So each copy that you infringer makes, it's attorney's fees for sometimes. If the behavior is egregious, you can get attorney's fees for copyright infringement.